Hey everyone, and welcome to my Week 5 presentation for Constitutional Law 2. This is my take on Marbury v. Madison, then and now. Let's get started. Okay, let's go into our key players in the situation. First off, we have John Adams. John Adams was our second president from 1797 to 1801. He is important here because of this. Up until the night before his successor's inauguration, Adams was signing in judicial appointments. It is said he did it as a way to preserve Federalist influence in the federal government. One of these men that Adams provided an appointment to was William Marbury, who was a successful businessman. On the bottom left there, you have Thomas Jefferson, who took over when Adams left office. He was our third president and kept office from 1801 to 1809. Next to him is John Marshall, who was in the position of Chief Justice of the Supreme Court starting in 1801, and he then went on to serve in that role for the next 34 years. Marshall remains to this day the longest-serving Chief Justice. Finally, there's James Madison. Madison is more known for his role as the fourth President of the United States, but before that, he served as Jefferson's Secretary of State. We take that future president's name and combine it with the successful businessman's name, and we get what is known these days as a groundbreaking case, Marbury v. Madison. Okay, let's talk about the case now. As we had already covered, President Adams had given Marbury an appointment the night before he left office. Jefferson then steps in as president and figures out what Adams had been trying to do with giving out all these appointments and told Madison, his Secretary of State, to withhold Marbury's. Marbury is understandably upset and appeals to the court, petitioning a writ of mandamus, claiming Madison withholding his commission was an illegal act. Before we go further, as you can see, I included the definition for writ of mandamus on the right-hand side, but let's go over it real quick, shall we? A writ of mandamus refers to an order by a court to a lesser government official to perform an act required by law, which he has refused or neglected to do. Okay, let's move on. So, Marbury enabled his claim on the Judiciary Act of 1789, which vested power into one Supreme Court and smaller courts. It didn't make any provisions for procedures of structure for any court that was transferred over to Congress. This is where John Marshall comes in. Marshall states the section was inconsistent with the Constitution and therefore was not a valid reason. This ended up becoming the first case ever where the Supreme Court struck down a law from Congress citing it was unconstitutional. So, what does this whole thing lead us to? The answer, ta-da, is the practice of judicial review. What is judicial review, you may ask? Well, once again, I have included a definition, but let's go over it. So it's defined as the power of a court to review legislation or other governmental action in order to determine its validity with respect to the U.S. Constitution or state constitutions. This is a way of saying that a court can strike down a law after review if they decide that it's unconstitutional. Below, I have listed some examples of court cases which are good examples of judicial review. You have Roe v. Wade, Obergefell v. Hodges, and Loving v. Virginia. Let's go into one of these cases and explain it to see how it fits in here. So we'll go over Loving v. Virginia. Back in 1958, Virginia residents Mildred Jeter and Richard Loving got married in the District of Columbia. When the couple returned home, a short time later, they were charged with violating a statute in Virginia that banned interracial marriage. The Lovings were given a guilty verdict and sentenced to a year in prison. However, the judge stated he would suspend that year if the couple left Virginia and did not return for 25 years. The case was taken in front of the Supreme Court, who in a unanimous decision for Loving stated that Virginia statute violated both the Equal Protection Clause and the Due Process Clause of the 14th Amendment. Chief Justice Earl Warren explained it with these words: "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." So where are we at now? The lasting effect of Marbury v. Madison would be the practice of judicial review. As we went over before, judicial review is not just a thing of the past, but still happens today. The Lovings case was over 50 years ago, but if you would like to compare it to something recent, check out Obergefell v. Hodges, which happened in 2015. That case deals with same-sex marriage, with one of the main questions centering on whether a state should recognize a same-sex marriage that was legally licensed and performed in another state. Not trying to give away the ending on this one, but the court sided with Obergefell with a 4-5 decision. Thanks everybody for tuning in to watch my presentation this week. I know we're all studying the same thing, but I hope that it maybe gave you some insight. I know that I like learning about it, and I'm excited to see everybody else's presentations. God bless you all in the remainder of your upcoming week.